to do over again, it would never have happened. We would have moved. But you don't get do-overs.
It's day 4 of testimony in the movie Popcorn Murder trial. We'll take you back to court in just a minute. The state is expected to rest their case in chief today. And the big question this morning, will the defendant take the stand? The now 79-year-old Curtis Reeves faces charges of second-degree murder and aggravated battery with a deadly weapon. He's accused of murdering Chad Olson 8 years ago. The jury has already heard a bit of what Reeves might say if he takes the stand. The state entered into evidence yesterday a recorded interview that Reeves did with police detectives immediately after the shooting. He claims the victim was the aggressor and that he was shooting in self-defense. On the stand this morning is former detective Alan Proctor. He conducted that interview with Reeves. At one point, the defense asked Proctor if he knew the defendant was a former police officer. When he spoke to him moments after the shooting, here's how the former detective responded.
Now, right before you go into that little room to interview Corporal Hamilton, you didn't know anything concerning his extensive training that he had.
There again, sir, he had just shot a man. It didn't matter if he was law enforcement, if it didn't matter who he was. He had just shot somebody, and at that time, that did not weigh on me as far as needing that information. I wanted to gather everything that I could to present to the court, and at that time I didn't feel the need to go into his background.
Detective Alan Proctor doesn't look at the defense attorney much when answering the questions. There's some tension in the courtroom. Let's get you back into the courtroom, pick up the cross-examination where we left off.
And you certainly, when you went to retrieve her, you didn't hear any police officers warning those individuals not to talk to each other?
No, sir.
And you certainly didn't give any instructions to officers to do just that?
That's correct, sir.
Okay. Now, since you took notes of both Corporal Hamilton and Mrs. Hamilton, you took notes there in that party room, correct?
Yes, sir, I did.
You don't have those notes because you shredded them.
That's correct.
It wouldn't have been difficult for you to just attach them as a piece of evidence, right?
That's not procedure, protocol. These are my notes.
So you want to follow procedure protocol concerning the destruction of the notes, but you don't care about following procedure protocol when you're interviewing individuals together.
Sir, it's been a few years since I read that procedure, but the thing that you do not want to do is interview two witnesses together without having at least one of those individuals interviewed. In this particular case, like I explained yesterday to the court, I had interviewed Mr. Hamilton. I had obtained the information that I felt I needed at that time. I had saw his wife. She was upset. I wanted to get the very best statement that I could from her. Mr. Hamilton knew not to say anything during the interview. He simply sat behind her with me facing her and him behind his wife at a different table.
Did you put all that in your notes, Detective, that you shredded?
No, sir.
Okay. So now you're done with both interviews.
Yes, correct.
And the one thing that you knew, that there was yelling and curse words that were being directed from Mr. Olson to Mr. Reeves, correct?
Yes.
Leaning over the back of the chair.
That's correct, yes, sir.
And so you would agree that is an indication to you that Mr. Olson was aggressive.
Objection, Judge. Can you approach?
Yes.
Can I have Shriver?
Sidebar, let's bring in Michelle Thomas in Silver Spring, Maryland, and joining our conversation, criminal defense attorney and former district attorney Matthew Mangino in Pittsburgh, Pennsylvania. Welcome. Good morning, Matthew. Michelle, your take on this cross?
Yeah, I mean, I think it's effective to an extent, but the defense is spending a lot of time on some of the details that just don't matter. I mean, he's trying to portray to the jury that there were some ill procedures followed, that there were some mistakes that were made, and therefore render his testimony unreliable or not as credible as the state wants it to be. But the fact remains that we're still looking at someone that may have threw popcorn at the defendant, who then in turn shot him fatally. So that's really the focus here. And then when you're using a deposition transcript, yes, it's often used to impeach a witness, but when a gap of 7 years or so has passed, any kind of inconsistencies become a lot less effective or meaningful. So I think that the defense is trying to focus on some of the tangential issues that are just not as relevant to the primary issue that's before this jury.
Yeah, Matthew, ripping apart the investigation is very common with the defense, but this is not a whodunit. It's not. We know who shot Chad Olson. Your take on the aggressive nature with this lead detective bringing up unrecorded interviews, shredded notes, and an interview done with two people saying that you botched the investigation.
Well, yes, I think that the defense is trying to make some gains any place that they can. Obviously, this is a difficult case. As you said, it's not a whodunit. We know what happened for the most part in that theater. And the question is, was it a self-defense issue? And I believe by trying to show that he didn't follow procedure, that he didn't separate witnesses, that he didn't get a full picture of exactly what happened in the theater that evening. Who was the aggressor? Was there more than popcorn thrown? Did the detective Proctor not follow up on leads that might have led to more information concerning what exactly happened there and what led up to the shooting? They're still trying to piece together a self-defense case, and they're going to try to do it by saying the jury doesn't have all the information from the prosecution about what happened in the theater.